It's the appointed time, and we have formed the quorum. This is a meeting of the Subcommittee on Food and Drugs, Composition and Labeling, Amendment Number 2, Regulation 2014. This is election of the chairman. The procedures for the election are set out at Appendix 4 to the House Rules. So, members, please make a nomination. A nomination should be made verbally and then seconded verbally by another member and passed by the members. Dr. Kwakaki, Dr. Helena Wong, any seconder? Professor Joseph Lee, Dr. Helena Wong, do you accept the nomination? Any other nomination? Mr. Wong Ting Kwong, Ms. Alice Mack, any seconder? Mr. Stephen Ho. Alice Mack, do you accept the nomination? Other nominations? If not, so, well, since we have not too many people here, shall we just decide and vote by a show of hands? According to the rules of procedure, the nominee will be allotted a number by the order of the nomination. Helena Wong, number 1. Alice Mack, number 2. So there is a ballot paper, and we're now going to distribute it. So please mark your choice on the ballot paper. Any member who has not been given ballot paper or the stamp or chop? So you've got it. So let's chop it. Are you finished? So please collect the ballot papers.
OK， 投票而家結束喎。
So the voting ends. All right, we've collected the ballot papers. Do we need to? Okay, the nominator can come and scrutinize the the votes. Shall we just make a counting now? All right. The results. Dr. Helen Wong, 3 votes. Ms. Alice Mack, 7 votes. So congratulations, Ms. Alice Mack. Will you now come forward to take over the chair, please? Thank you, members. I'd like to ask whether we need to elect a vice chairman for this subcommittee. No? All right, okay. Then we would invite the administration team in. Now, we would have a meeting with the administration. Perhaps the Undersecretary would take us through the amendment regulation, please. Good morning, Madam Chair and members. This is to study the Food and Drugs Composition and Labeling Amendment Number 2 Regulation 2014. The government is committed to protecting the health of infants and young children, and they must obtain optimal nutrition from the diet to grow and stay healthy. Breastfeeding, of course, is best in ensuring physical and social health and well-being of mother and child. Where breastfeeding is not feasible, infant formula is the only processed foodstuff which wholly fulfills the nutritional requirements of infants during the first few months of life. So we must ensure that infant formula is safe and nutritionally adequate. For formula products and prepackaged food for infants and young children under 36 months old, we think that food label is important to promote a balanced diet. The Center for Food Safety found in August 2012 that formula products were found to contain iodine at a level lower than prescribed. So we need to legislate on the nutritional composition and labeling. After consulting the public and also consulting the FESH panel, and after the law drafting process, we are now presenting to the LegCo the Food and Drugs Composition and Labeling Amendment Number 2 regulation. The amendment regulation. The government hopes that through this amendment regulation that formula products and prepackaged food for infants and young children under 36 months old are properly labeled to reflect the content of the main nutrients. And also the infant formula should provide adequate nutrition to ensure infants and young children's health. Now, in drawing up our regulation, we have taken reference from the Codex and international practices. We have also taken into consideration local market and consumption situation to ensure that our proposals bear regard to international standards and local situation. And details of the legislation are below, as below. Definitions of, the labeling, nutritional labeling. The nutritional labeling scheme, under it, 1+7 is not applicable to formula products and prepackaged food for infants and young children under 36 months. So the government suggests that based on Codex standards, that labels of infant formula should have a label of 1+29, and for follow-up formula, the labels should contain information on the energy value and 25 nutrients, i.e. 1+25. And for formula products and prepackaged food for infants and young children under 36 months old, the label should also contain information on the energy value, protein, fat, carbohydrates, and sodium, i.e. 1+4, and also vitamin A and vitamin D, if they are included. As for the nutritional composition, based on Codex standards, the government will mandate that infant formula should have energy value and 33 nutrients, 1+33. And the nutrients should also comply with the standards laid down by Codex. And for some nutrients, there is also a requirement on the proportion. Now, apart from the 33 nutrients, since Hong Kong market, in the Hong Kong market, formula products do have contain taurine and DHA, and so that's why the government mandates that the maximum level of these substances must comply with certain requirements. Now, also fluoride. Excessive intake of fluoride may increase the risk of dental fluorosis, so we propose to regulate fluoride in infant formula by requiring infant formula to be labeled with a statement associated with dental fluorosis. Now, as far as exemptions are concerned, we have made exemption for formula for special medical purposes for infants and young children. But they must be labeled specially. Formula for special medical purposes for infants and young children are formula products to meet the needs of infants and young children with specific disorders. So they have to be manufactured specially, so their nutrients may vary depending on the diseases to tackle the relevant diseases. So we believe that such an exemption will not compromise the safe use of such a product, because they are normally administered under medical supervision. Most of them are not being sold on the retail market locally. The government also suggests that we should model after the current nutrition labeling scheme, i.e. providing exemption for products with small package size. Now, grace period to allow the industry to have sufficient time for preparing for the regulation, and also taking into consideration of the calibration of the products. We suggest that for follow-up formula and prepackaged food for infants and young children, there will be a grace period of 2 years. Now, given infant formula is the sole source of nutrition for infants, a shorter grace period of 18 months is proposed to better protect infants' health. Now, as for penalty, After the regulation comes into effect, the offender will be fined a maximum of $50,000, imprisoned for 6 months, and the penalty is in line with that relating to the NL scheme. I welcome the Madam Chair and members' questions.
Thank you, Under Secretary. Mr. Vincent Fang, followed by Mr. Wong Ting Kwong. Thank you. First of all, I'd like to state in principle that I support the proposed nutritional labeling requirements so that the users would benefit. So my question for the Under Secretary is whether or not we're going to do this by negative vetting. Yes. I think we would be, worried whenever we hear the term negative vetting. Mr. Vincent Fang, why don't we set the rule that each member be given 5 minutes? Okay, I'll try to be as brief as possible. I understand that the regulation was gazetted on the 13th of June, and I'm really confused. So for infant formula, the grace period is 18 months, and I don't know whether or not it's 24 months. So, in other words, the grace period already started from the 13th of June. I think it happens every time. When you propose nutritional labeling, the same thing happened. This also happened in the case of the Pharmacy and Poisons Ordinance. I would like to ask whether or not we can invite the stakeholders to express their views. I've heard a lot of views from those in the industry. Secondly, you told us about the proposed arrangements for infant formula and follow-up infant formula, and that the regulation come into effect in 18 and 24 months respectively. Why can't we simply have a standardized grace period and set it at 24 months? Otherwise, you have 18 months for one category and 24 months for another category. It would create a lot of confusion because these products are typically not manufactured in Hong Kong. And also the labeling requirement of 1+33, 1+25, and 1+29. I'm really confused. So have you also tried to localize the requirements, because these formula products are manufactured abroad, and it will be difficult for manufacturers to produce them locally. So I hope the Bureau will consider all these suggestions. Also, the grace period, you're proposing 18 or 24 months. For some of the smaller manufacturers whose products are not so popular, for the more popular brands, I'm sure they'll be able to sell all the stocks within 18 months. For those brands which are not so popular, if the product were manufactured before the date of Gazette, would you consider giving them some exemption? Just now you talk about the iodine content for formula products. Very often the products are not manufactured for the Hong Kong market. Sometimes the users will buy such products online, and they may be tailor-made to the Japanese market and not the Hong Kong market. And the government is now proposing that's not right, and we need to impose additional restrictions. But these formula products are not, so popularly in Hong Kong, and only very few people actually buy them online. You raised the question about negative vetting. The answer is yes, and the grace period will start will start counting from June the 13th. You made the suggestion that, or rather you asked the question whether or not we can't standardize it to 24 months. The Center for Food Safety originally proposed a grace period of 1 year. In the course of the consultation, public consultation and consultation with the trade, during our technical meetings, we've heard the views of the trade and have come up with the adjustment that it be 24 months. We believe that infant formula products are more important, and we would like to regulate that as soon as possible. For other than breastfeeding, infants below the age of 6 months will rely on such infant formula products. That's why we've tightened it to 18 months. From the original conceptual stage, we've already made some adjustment in respect of the grace period. Regarding the 1+29, nutritional composition, basically we follow the Codex approach. So for formula products which are imported, basically I think they should comply with the Codex requirements. In our meeting with the trade, they also found that there wouldn't be any major difficulties in terms of compliance. For the less popular brands which only small quantities imported, I'll ask the department to supplement. I think before we decided on the regulations, we conducted a survey. We found that about 70% of the infant formula products sold in the market and also follow-up formula products satisfy the labeling and nutritional labeling requirements. Mr. Fang referred to some products which are sold in small quantity, which are not very popular, and only very small quantities are being sold. The purpose of the regulation is to protect all the infants in Hong Kong. So whichever products are being consumed by the infants, we hope that the parents can use the label to help them make the right choice, and also to ensure that in these infant formula products, all the ingredients, required by the Codex are there. So what about products which have already been imported before Gazette? Would you consider giving them a grace period or an exemption? Permanent Secretary, when we decided on the grace period, we had consulted the views of the industry. We believe that 24 months are sufficient to enable the trade to dispose of the inventory. The 24 months would not only be sufficient for them to dispose of their stock, it would also enable those products which fail to comply with the requirements to comply with the new requirements by adjusting the composition of their products. So we, after careful consideration, we have decided on the 24-month grace period. Mr. Wong Ting Kwong. Thank you. First of all, the DAB supports the enhancement of the requirements for nutritional labeling for infant formula products. But having heard the views of the industry, I'd like to express the following views. First of all, the formula products are also regulated by the food labeling regime. We're just enhancing the regime. I don't know whether or not by doing so our system will be in line with international standards. When we formulated the food labeling requirements, I think those requirements were slightly different from the international standard. And the nutrients required by our regular regime are different from some other countries, especially mainland China. And many of our products are supplied by the mainland. So if there are any discrepancies, would you consider, addressing that issue? And secondly, the grace period issue. I understand that that has now been relaxed from 12 months to 18 and 24 months. To some extent, we would like to have a standardized approach. For the importers, I think we should minimize the inconvenience or disruption for them. I don't have any set position. I hope that you can try your best to relax it to 18 to 24 months. So far, we have not had any major issues with infant formula products. So far in Hong Kong, infant formula products have always been safe, and we've never had any serious issues. So should we, do we need to make such drastic changes within such a short time? I think we need to deal with it cautiously, because we also attach a lot of importance to the health of infants. Thirdly, the proposed penalty is a level 5 fine, $50,000 and 6 months imprisonment. Is this in line with the penalties for breaches of the food labeling regulations? And if the grace periods would start from the date of Gazette, that is June the 13th. Are you talking about the day on which the products were put onto the shelves of the retail premises, or would you start counting from the days the products were imported into Hong Kong? There might be a discrepancy there. So I'd like to know, which is the case. Let me answer Mr. Wong's last two questions, and my colleagues can also answer the question in relation to penalties and also about the timing of the import of such products. As to whether or not the proposals are in line with international practices, for products to be consumed for infants below and above 36 months, the nutritional requirements are different. For infants below 36 months, we follow fully the guideline of the Codex, and the requirement is that for both the composition requirement and the labeling requirements, we follow the Codex guidelines. Could you be more specific, and are you following the EU or standard or whatever? Don't just say that you basically follow the Codex requirements. Perhaps I can supply Mr. Wong with the details after the meeting. Let me also answer your second question, that is whether or not that could be a standardized treatment. I think the Center for Food Safety has considered this for a long time. If we were to consider this issue further, I don't know whether or not we'll end up with a standardized grace period of 18 months. I understand some members would want this to be extended to 24 months, but we'll certainly be prepared to consider that. But if there should be a standardized, grace period, I'm afraid that we may end up with an 18-month grace period.
On the proposed penalty, and that is in line with the two sets of labeling regulations. One is the nutrition labeling scheme, and then the other one is on the prepackaged foods for people or young children about 36 months old. Now, what is the scope? After the grace period, all formula products sold and promoted will be covered under the regulations. My question is when or where would you enforce, at what point would you enforce the regulations, at the retail point or the wholesale point? Now, retailers may have stocks containing old labels. They may not sell them. Or importers may import goods for re-export. And this is an important factor in our business environment. So I must get a clear answer. At what point would you be enforcing the law? At the retail level or where the goods are imported? What I meant is activities undertaken for selling the products locally. Now, you mentioned about situations where the products are re-exported, then those are not covered. So the administration is very categorical in saying that the regulation applies only to products sold locally. Mr. Wong, Ting Kwang asked about international standards. Can you give us a paper later on the list of countries doing what and so on? Mr. Tan Ka-piu. I think I have a question on the sales process. There are online selling platforms, and we don't know whether they are sold by individuals or retailers or what, but there are a lot of online sales activities. So are they covered? Now, say if this is an individual, judging by the accounts and so on, selling the products, so is he covered under the regulations? Second, there are services related to young children and infants, like private clinics and playgroups in kindergartens. They may give away for free infant formula products. And of course, that was really done to gain wider support from the parents on their establishment. So are these covered under the regulations? They may not carry any labels, but then they are given out in large volume. How are we going to deal with those situations? Under Secretary, thank you, Mr. Tang. Let me take the second question first. Once the regulation is enforced, infant formula, follow-up formula, or prepackaged foods, all those should carry labels specified and should contain the required nutritional composition. Now, you mentioned about giveaways in small packets or what, and perhaps we can go back and take a look. Perhaps the PAS can supplement. We will have to look at individual situations, the facts related to those situations. Mr. Tang mentioned about a kindergarten giving away infant formula for free. How is the process? For what is it given out? Is a certain benefit involved, and so on. So we can't give you a general answer here, and how they will be covered under the regulation. Now, please give a clearer reply. The Undersecretary give an answer based on some assumptions. Perhaps an establishment has received a large volume of infant formula products, and we don't know the source. But then what is most important is the one who is giving out the product. Is he covered under the regulations? Giveaway. Now, if it is not for sale, that we really have to look at individual cases. Now, you talk about an individual selling products online. If it is a sales activity, it's definitely covered under the regulations. Well, perhaps later you can give us some supplementary information. I want to follow up. Now, giveaway. The the formula are imported foreign brands. There may be labels already on the products in English or in Thai or whatever. So is that acceptable? Now, giveaway. We have to look at the facts of each case. Now, if the giveaway activity is governed under the regulations, they must adhere to the regulations in terms of nutritional composition. Next, Mr. Kwok Wing Hang. Well, we all agree to the proposal of having nutritional labeling. In the paper, it says that the Codex has certain standards drawn up already, and we should follow duly. Now, for Codex, are the manufacturers required to take their products to test and get the certification before they can sell them in the market? Now, under our regulations, are we enforcing the law through random checking, or we would be checking that the nutrition labeling is in order before the products are allowed to be sold? I don't want to see the situation where we would take action after problems have arisen. Should we be checking the information beforehand before the products are allowed to be put on shelf? Second question on exemption. Formula for special medical purposes, FSMP, can be exempted. Now, these are if these are taken as medicine, then that's all right. But if such FSMP contains the usual nutrients and also some medical elements, and it is taken for a long time, so should we still be allowing for exemption for such products? Or more basically, whether such products exist at all? Last question about the 100 square centimeters. Now, if there isn't enough space on the label, then that's all right. No need for labeling on the nutrients. Now, on the market, do you know how many products? How many products have a surface area of less than 100 square cm, and which means that on each side there is less than 16.6 centimeters. Now, how come that you draw a line there, delineated as 100 square centimeters? Why don't you allow, or why don't you require all products to carry labels? Can they do it by way of a sort of do it on the packaging? All right. Thank you, Mr. Kwok, for your question. You want to know the details. Perhaps a colleague from the Center for Food Safety can take that question. Dr. Chen. Madam Chair. For Codex, it doesn't require that checking be done before the products are offered on the market. But the standards do set out the nutritional composition, nutrition labeling requirements. As for future enforcement, perhaps I'll defer to the colleague responsible for law enforcement to supplement. Every year, we will check the nutrition label of 15,000 products. Can you speak up? The CFS will randomly check around 55,000 products to ensure that they comply with the regulations. After the grace period expires, the CFS will, based on the such standards, check on the the labeling of products. Can the administration do a more proper job? Well, it's important that young children be given the right food, or else we will end up with great problems. So will the government check the products first before they are allowed to be put on shelf? Perhaps the PAS can elaborate on the process. Well, the government shares the same views as members. We attach due importance to the safety of baby food. So it's precisely because of this that apart from regulating on nutrition labeling, we have also requirements on nutritional composition based on Codex standards. Actually, we are checking some 50, more than 10,000 formula products every year. Now, as to the members' suggestion of checking first before selling on the market, then as far as we understand, this is not in line with international practices. Nowhere in the world is such an approach adopted. The approach that we will be going is one suggested by the Codex, and that we think should suffice in ensuring babies' health. Surface. Well, we don't have the information on hand. Perhaps we can give you the information later. Your second question about special medical purposes, formula for special medical purposes. Now, babies in small numbers may have special disorders, and they need special infant formula with certain elements added or deleted. Now, babies may have special disorders, so their diet must be administered by the doctors. So such FSMP is administered by doctors, and that can help enhance the safety of the formula. Well, we've consulted the trade on this particular issue, and actually the number of such products is relatively small. Now, if we have imposed on them special requirements, then that may bar them from coming to Hong Kong, such products from entering Hong Kong. And then that will not do any good to babies who have such needs for such products. So maybe I have exceeded 5 minutes, but can I have a follow-up, if you don't mind? Oh, sorry, next round. Next. Dr. Joseph Lee, negative vetting. Now you have gazetted, and that the time counts as starting 13th of June, and the retailers and the wholesalers are very clear about the regulations already. And today is the 2nd of July, and we will be having a public hearing too. Now, if the regulations don't work out, then what should the retailers and wholesalers do? Now, if we don't let you go, so what will happen? Negative vetting. Now, the trend seems to be the government is trying to, ram something down our throat, and this is a trend. Now, this is not a new proposal. I have a few questions or issues of concern. Nutrition labeling. While 50% of the products are found to have 1+33, but for Codex is 1+29. So nutrition labeling, should it be 1+33 or 1+29? Well, most of them are 1+33. Why don't you go by that instead of 1+29? Now, for all types of formula, actually they are 1+33. Now you are suggesting 1+29. Should we be reprinting all the labels? Now, you may say that, well, we have 4 extra more, then there is no need to reprint the labels. But then we were told in the past that you must have 1 plus 29, and you should reprint the labels. And you are not allowed to print to carry four more nutrients in the label. Now, second question about is DHA. You want to regulate on those claims. Do you have any standards? Well, then it's no longer 1 plus 29, but 1 plus 29 plus 2. Now, if in the 1 plus 33 labels they do contain these 2 other substances, then that seems acceptable. So it's all very confusing. Now, I'll talk about the 18 months and 24 months later. Now, so if I am the buyer, shall I look at 1 plus 29, 1 plus 33, or what? So, negative vetting has a problem. So please elaborate. Grace period. Vincent also asked, can you not differentiate between the infant formula and formula?
Yeah. If you want to restrict, you set it 18 months, but then the industry would complain. And then you decided on a compromise and say for the follow-on infant formula products, the grace period is longer. For infant formula products, it's shorter. And the parents will be confused. Why didn't you simply have a standardized grace period, either 18 or 24 months? I think your law would need to be precise. You cannot be, it shouldn't be so confusing. I think it would be the end user who suffer most, because the mother wouldn't know, what kind of products they should choose. Finally, about people buying formula products online, how are you going to take enforcement action? If I go to Taobao and buy a few cans of formula products, I wouldn't say necessarily it's from the mainland, and they're sold in Hong Kong, how are you going to take enforcement action? Would the mothers know? And if they order some products from Japan or Holland and are told that it's not legal, what should they do? Let me answer Mr. Lee's question, and then the Center for Food Safety can also supplement. Thank you, Mr. Lee, for raising the issue of 1 plus 29 and 1 plus 33 requirement. The Codex requirement for nutritional composition is 1 plus 33, but the labeling requirement is 1 plus 29. So we have therefore fully followed the Codex labeling requirements, namely 1 plus 29. The labels currently in the market, most of them have 1 plus 29 nutrients. So we're not different. So our approach is not different from that of the Codex. It's not a special requirement on the part of Hong Kong. We have completely followed Codex recommendation. But the composition requirement is 1 plus 33 as far as the Codex is concerned, but the labeling requirement is 1 plus 29. Perhaps the Center for Food Safety can explain further. I think there's nothing wrong with 1 plus 29, but if the product comes into Hong Kong with a label of 1 plus 33, then they have to, fix it with a new label. I understand that if the product satisfy the Codex requirement, the label will be 1 plus 29. For products with labels containing 1 for energy and 33, nutrients, and they would already satisfy the requirement. I think you need to spell this out clearly, otherwise the manufacturers would be confused. Why don't we, give us a paper confirming this point? That is, Mr. Lee made a very important point as to whether or not the labels for some of the products would need to be printed again. Well, we've heard your view that perhaps as to whether or not there could be a standardized approach. Mr. Wong also asked the same question. Regarding ordering formula products online, we've also noticed that many people now buy products online. For the surveillance conducted by the Center for Safety, we would look at all kinds of products. And if when this new regulation comes into force, we certainly also pay particular attention to people buying products online. What about the two different, grace period? I understand members' concern. All members would like to have a standardized grace period. Where initially we considered allowing a shorter grace period, but having consulted the industry, who told us that they would prefer a longer grace period, and that's why we've come up with this 24 and 18 months requirement. If members all agree that there should be a standardized grace period, the Center for Safety may standardize the grace period to 18 months. We can certainly go back and think about this further. Regarding the question on negative vetting, the Permanent Secretary could answer that question. Mr. Lee asked whether there will be sufficient time to consult the industry if there are major changes after the negative vetting. Actually, before we proposed this regulation, we conducted extensive market survey, and we found that about 70% of the infant formula products and follow-on formula products already, 70% of those products already satisfy the requirements in terms of labeling and nutritional labeling. So I think the proposed timetable is sufficient. What would happen if there are drastic changes, as one member asked? The commencement date can be changed. Certainly, the position of the government is that if we're going to regulate the formula products in this format, the grace period is sufficient. In the course of scrutinizing regulation, if there is members found that there is a need for drastic changes, then we will certainly be prepared to review this time period. What about purchase of formula products online? Since more and more people are now buying such products online, as I answer Mr. Kwok's question, even if the products are sold by an individual, such individual would still need to be subject to regulation. You know that when people order through Taobao or online, the products are simply ordered from other countries and imported in Hong Kong. Well, the Center for Safety also conduct online monitoring. Online purchase can take different forms, and I believe for people there are different ways to sell products online which are not legal in Hong Kong. So I think we will need to look at the facts of individual cases to see whether or not there is any breaches of the law. So I can't give you a standardized answer. Perhaps you can also give us supplementary information as to whether the regulation could cover online purchase, because this is very controversial. So are you going to monitor online purchase or sale of such products? And under what circumstances could this regulation be invoked, and under what other circumstances it could not? Dr. Helena Wong, thank you. I agree that we should invite deputations to express views other than the suppliers of formula products and the retailers. I hope we will be able to also invite parent associations, because they are the consumers and the users, and also nutritionists, because they know they are familiar. They have they have expert views regarding the nutritional value of formula products. I'm also concerned about the grace period, because it's 18 months for some products and 24 for the others. So I think it would be better that we have a standardized grace period, and I would prefer that it should be set at 18 months. because I'm very concerned about the safety of infant formula products, and I think parents should be given clear information. Milk formula products are not manufactured in Hong Kong. Now, if the grace period for infant formula products to be 18 months, they certainly have the ability to comply, whether or not it's 18 or 14 months. Same for the follow-on infant formula products. They can also, cope with an 18-month grace period. And if they if they cannot meet, if the 18 months is not sufficient, I'm sure there will be other markets that can absorb the product. So if we insist, then I think the 18-month grace period should be acceptable. Regarding the 1+29 and 1+33 requirement, I'm worried that there might be enforcement problems. Although, according to the Codex, the labeling requirement is 1+29, but we want all infant formula products and follow-on infant formulas should include 33 ingredients. So there are 4 ingredients which need not be spelled out in the label. So what are those 4 ingredients? And why is it that all those 4 ingredients must be included but does not have to be specified on the label? So when a Center of Food Safety inspect this particular infant formula products, by what standard do you judge whether or not the product complies with the requirement in respect of those 4 ingredients? If there's a minor if it is, or for those 4 ingredients, if they exceed the margin slightly, would you take enforcement action and so on? So I hope you will explain that further to us. Regarding 1+29, let's say the label spell out 1+29 ingredients, and on the cover of the can you spell out the ingredients by weight or volume of those ingredients. So when you take enforcement action, if the nutrients labeled on the product is not the volume of that nutrient is not the same as what is claimed on the label, if it is 0.1 and then the ingredient and it turned out to be 0.09, so would you accept that? So what would be your tolerance limit? That is, what is the margin you would allow for deviation? Because if this is not clear, then the label would become useless. So would you enforce the regulations leniently or strictly? So how exactly do you propose to enforce these requirements? Thank you, Dr. Wong. Ms. Wong suggested that we should invite deputations, and we have no strong views on that. But I'd also like to tell members that over the last few years, we've heard the views of many deputations. In November 2012, we conducted a deputation. During that period, we conducted a public consultation and had technical meetings with the trade. But if members feel there is a need, we have no objection.
I've also heard Dr. Wong's view that the grace period should be standardized, but as I said just now, we would go back and study it. As for the 2 other questions, perhaps I would defer to the CFS colleagues to take 1+33 and 1+29. The 4 ingredients, what are they? And if they are not there, what will happen? So CFS, please explain. Madam Chair, 1+33 and +29. The 4 nutrients are linoleic acid, a linoleic acid. Sorry, can you speak up? The 4 nutrients are linoleic acid, alpha-linoleic acid, myo-inositol, and L-carnitine. For these 4 nutrients, in our regulations, they have to be of a certain level in the infant formula. The regulations don't require them to be included in the label, but such nutrients should be included in the infant formula as required by the regulations. Can CFS give us the level, the exact level, 1 plus 33? Can they give us a paper to this subcommittee on all the different levels required under 1 plus 33? Undersecretary, can you give us a paper later? And we asked her what international standards are you trying to follow, the practices in other countries. Can you give us a paper on the list of nutrients and also the standards of their amount and so on? Madam Chair, he hasn't answered me the question on the tolerance limit. Should there be a standard value and then a tolerance limit value? Well, there are certain principles on the tolerance limit. PS, tolerance limit. I'll talk about the principles and then I'll defer to the CFS colleague to give you the details. Tolerance limit applies to the marked value, and the difference between the marked value and the value obtained from laboratory tests. For infant formula, we have a certain requirement on the content, and that should not deviate at all from the regulations. And for tolerance limit, only applies to the value on the label. The difference between the value on the label and the value of the tests. And that approach is adopted in many different countries. Why this approach? Because in the nutrients of infant formula, their volume may decrease over time. So that should be some tolerance limit for the manufacturers, and that can't be indefinite. So internationally, there is a common consensus on how the tolerance limit should be drawn up. CFS? We would mainly look at, for the different nutrients, the nature of the nutrients. Are they natural nutrients or additives? Now, for better nutrients, like protein and other similar nutrients, we would take reference from the present NL scheme and other international presence. It should contain, it should be 80% or above in terms of the volume. For other products like trans fat and sodium, the content or the volume should not be 20% above what is the standard. All right, can you give us a paper on the tolerance limit, the standards, and the nutrients and so on? Madam Chair, I think this is so very important. We must have such information before the next meeting. Madam Chair, I don't think we can accept that. If the nutrients are good nutrients, and they are really the major source of nutrients for the babies. And we can't give a discount of 20% per se on such nutrients. I would, Mr. Stephen next. I would like to ask questions about online sale. Well, that was raised by Mr. Kwok. Now, in the community, mothers would hope that babies get better nutrition. If you put 1 plus 33 on the label, how many mothers would actually look at the labels? People like purchasing baby products online, and for the formula products without adequate iodine, they come from Japan because the diet comprises a lot of fish and they don't need that much iodine. And for Hong Kong people, it's not like that. Our pattern's not like that. So there is a loophole there, and the greater risks are incurred. I think you should do something on that. You shouldn't be saying to us that you'll go back and study because people are changing the way they are selling the products all the time and so on. So I think it's a livelihood issue and you must do something. That's my opinion. Secondly, Madam Chair asked you to give us a paper telling us the standards of the codex. Approximately, you will be roughly following the standards of the codex. Can you tell us now exactly or precisely how much you are following the codex standards? 80% or 90% or what? Next question is on negative vetting. I mean, it has become the norm for you. For labeling of infant formula, is it such a pressing issue, so pressing that we have to use negative vetting because it has all the impact on sales in the future? Now, many people buy products from supermarkets like Welcome and so on. Now, you put a sort of gate on the 13th of June, Gazette date. Now, as a retailer, should I still be replenishing my stocks? It has to do with the supply chain. We have time to further discuss, and then after the discussion, we can give a grace period of, say, 18 months or 24 months. And I think, please don't make negative vetting a norm. Please don't resort to negative vetting. Lastly, consultation. After having heard Mr. Vincent Fang's remarks, I think what he said differs from what you're understanding. You said the trade finds it acceptable, but then Mr. Fang said the trade has great opposition. So how did the consultation go? How come that Mr. Fang think that there would be a lot of problems in their operations? I mean, did you have? Is it a problem with there? Is there a problem with your consultation? Thank you, Mr. Ho, for your question about Japanese baby formula. We plan to undertake public education on that. You rightly pointed out that apart from following the Codex standards, we have also to consider our local situation, and not just the trade's views, but also the needs of Hong Kong babies and young children. So these are all our considerations. Now, on the website, there are situations beyond our control, sales activities going on beyond our control. So the best approach is to enable members of the public and the consumers to have a clear understanding. So we would definitely step up our public education on nutrition, composition, and labeling. Now, as for the question of negative vetting, I heard your views. Since 2012 or even before, we held technical meetings with the trade. And we actually, the CFS have regular meetings with the trade, and we've told them what they should do if the regulations are made. To my understanding, the CFS told us that the trade doesn't have any problem. Of course, everyone hopes that the grace period can be longer. Concerning the consultation, we are doing it in two aspects. First is the undertaken by CFS with the trade, technical meetings held and so on. And in November 2012 and January to January 2013, we had a 2-month consultation, and that covers the trade, individuals, and they wrote into us. And in March 2013, we came back to the panel to report on the consultation results. As to your question about how we followed the Codex standards, perhaps the PAS can supplement. We can give you a paper after the meeting, but perhaps I'll say here that for infant formula, we will be requiring the regulations on the nutrition composition and nutrition labeling. And we are following some 90% of the requirements of Codex. Now, as for follow-up formula and young formula for young children, we are also following Codex in the labeling requirements. As for prepackaged food for infants and young children, for the labeling requirements, we are fully following closely the requirements of Codex. The details to be set out in the paper to be given to the panel later on. Second round, Mr. Tan Kao-pui, 5 minutes again. I'll ask some technical questions. Exemption for total surface of 10 cm times 10 cm.
我咁假設，如果佢係一啲即係方形扁踢踢嗰啲，即係可能係試用裝。
If they are sample packets, would you count both sides of the packet or one side only? If you count single side, 10 cm plus 10 cm is rather large. If it is both sides, then 10 plus 10 cm would only be half of that. So are you talking about the size of both sides or just one side of the packet? Secondly, definition of infant. You said it at 12 months. Do the other jurisdictions have the same definition? And thirdly, well, I'm a father myself, and I think for parents who need to take care of children, they also are confused that they will, choose, the formula products according to the age of the infant. For some infants, the digestive system may not have developed, sufficiently to have the ability to absorb, more protein, or they may not be able to consume follow-up formula products, even though they've already reached the age. So, would there be a problem there? That is setting the threshold at 12 months to differentiate between formula and follow-up formula products. And the Secretary, Mr. Tang, let me answer your last question first of all. Codex adopt the standard of 12 months from the nutritional value for infants and toddlers. Those who are over the age of 12 months can already consume, general food products and may not have to, absorb the nutrition solely on formula products, but from other food products as well. So this time, we have made a distinction between formula product and follow-up products and pre-packaged food for infants and young children. The rationale for the proposed regulation It's exactly that. Regarding the size of the label, the Permanent Secretary can also supplement. Regarding the exemption, there are two exemptions in respect of the size of the label. The 100 cm, we're talking about prepackaged food products, or for example, infant food in small bottles. It's not a large can of milk formula products. For infant formula, it's 250. For the surface area, what do you mean by surface area? I'll ask the CFS to further explain. The surface area means the total surface area. Simply put, if we talk about the box, we're talking about so, or if it's flat in shape, we'll count both sides. Are you saying that the entire, label unfolded, and this area where the label could be affixed to? So a rectangular, package you will include 6 sides. So would that be different for infant formula? Codex standard is 12 months. We follow Codex because Codex has conducted scientific studies, and they concluded that if we need to regulate formula products, I think this is the best way, the ideal way to make the distinction. I'm assuming that in some countries, the definition of infant is 6 months. I think in the regulation, the definition of infants is very clear. I think Mr. Tang is comparing this particular regulation with other local legislation. In the amendment regulation this time, we have not provided a specific definition of infant, but rather we are focusing on the products. So members do not have to compare this with the definition of infant in other legislation, because this time we're only defining the infant formula products. So we do not specifically have to provide for yet another definition of infant. I don't understand. Perhaps as we go to the clause-by-clause scrutiny of regulations, the members will be able to see that we have not provided a definition for infant, but rather we're talking about infant formula products and follow-up formula products. Perhaps the DFJ can check the definition of infant in other legislation as to how it is defined in terms of the number of years or months. I just want to ensure that your proposal will not be subject to challenge. Mr. Kwok Wai Keung. Sorry, I'd like to take this opportunity while we still have a quorum, that at our next meeting, some member suggested that we should conduct a hearing. So the Secretariat has now proposed 2 dates, the 18th or 22nd of July. So we will inform members of the date of the hearing in due course. For our next meeting, we will conduct this public hearing, and also for the next session of this council, we would like to move a motion for the extension of the period of scrutiny for this regulation, because after conducting the public hearing, with this subcommittee may need to conduct more meetings. I'm sure members will want us to have the next meeting only after we've conducted the public hearing. Are we agree on this, Madam Chair? I don't know whether we should first clarify all the legal issues before we invite the deputations to come and meet us, or instead of meeting the deputations at our next meeting. because the amount of deputations, we may have experts on food safety, nutrition, and food testing. Now, if members, I think members should certainly suggest names of individuals or experts that we should invite to the hearing. I'm also worried that we may not be able to conduct a public hearing during the time when we're in recess. So could the Bureau, that is before we conduct the public hearing at the next meeting, give us the supplementary information requested by members, especially Mr. Wong's concern about the ingredients and the tolerance level. I'll supplement on that in a while. And also purchase of formula products online. Could you give us all those supplementary information so that we'll be able to receive your paper before the public hearing? All right? If members are agreeable, then we should adopt that arrangement. And Mr. Kwok Wai Keung, you're next. Thank you. So for the list of deputations to attend a public hearing today, would it also include doctors and nutritionists? That's my first question. Secondly, the Deputy Secretary, the Undersecretary said that formula products for special medical needs, they are not consumed in large quantities, and therefore the government is proposing to exempt such products. Well, I, on the other hand, believe that we should try our best to avoid ambiguities and confusion. Say, a child, so if the child has a special disease or some nutritional needs and therefore need to consume those special formula products, and the parents would like to know the ingredients of these products. So the parent may want to know why such products are exempted. After they bought the product, they may go online and search the ingredients and make comparison to see whether there are other better choices in the market. So I don't know why you propose to exempt these products. And secondly, the size or the area of the label. I asked how many labels there are in the market with the size of less than 100 square centimeters. I'm worried that in future all the labels claim that the products are fresh, and they would, reduce the capacity and the label, and thus bypassing the requirements in the regulations. There are some infant food which are in small bottles and therefore can bypass the regulations and the requirements in this regulation. Now, first of all, for formula products for special medical, needs, members also asked whether the deputations we invite to the hearing should include doctors. Actually, CFS also have doctors who are experts who can also attend. Now, the requirement is 1 plus 33 or 1 plus 29. For these formula products for special medical needs, they will not comply because the child who consumes such products may need to consume products with some of the ingredients excluded or included. So the doctor would explain to the parent about the special needs of his or her child, and hence the need for the child to consume such special products. Of course, we will certainly also step up public education on this point. You also asked a question about numbers. I don't think we have the information offhand. We certainly provide the information afterwards for members as to why why we exempt, pre-packaged food products in respect of the size of labels. For products with a size of less than 100 cm, then there are many such products, and of course, even if you have a label, the words will not be legible. For infant formula products for special medical uses, other than explaining to members the reason for the exemption proposed, the manufacturers and suppliers, there are very few such manufacturers and suppliers in the market. There are very few infants which need to use such products. So a single product can supply to many different markets. If we come up with a labeling requirement which is different from those of other countries, the consequence may be that these products will not come to Hong Kong. And we're worried that infants or children who need to consume such products would suffer as a result. Madam Chair, the purpose of setting the regulation is to protect the health of the infants and to also, provide the necessary information for parents. And apparently, the administration's argument is actually to make it convenient for the suppliers. It's not entirely. We're not proposing these. We're not making these proposals for the benefit of the business sector. We're worried that for such products with limited demand, and if they don't come into Hong Kong anymore, then Hong Kong children who need such products may not be able to buy them. Then we would be worried. We believe that, well, since such products can only be consumed based on doctor's prescription, and the doctor would check that the ingredients are safe for the child concerned. So we believe that there is sufficient safeguard there already. Helena Wong, I hope the Madam Chair can ask the Bureau to give us a supplementary paper on the tolerance limit, because your paper has not touched on this at all, and I think this is very important. You're now talking about the stringent labeling requirements, but the testing value and the labeled value, we just learned that there is a gap. So what would be a reasonable tolerance level for that? I already made some queries. For the good ones, you say a tolerance level of 80% is all right, and I don't think that is acceptable, unless the label value and the tested value. I think you have good reasons to ensure that the label value is as it claims. Otherwise, you have to give us the reasons why you would tolerate a gap. The 1 + 33 are So we need a paper explaining clearly why this regulation doesn't require the tolerance level to be prescribed in the law or the regulations.
Though, if there isn't any such requirement, how are you going to take enforcement action? Does it mean that the value can change all the time? And for other jurisdictions, what is the range of the tolerance limit adopted by other jurisdictions? Can you give us a list in your supplementary paper? And what is the recommendation of the CFS in the tolerance limit, 1 + 33? Well, and then we can have a discussion based on that. Now, for some jurisdictions in regulating the nutrients of infant formula, they adopt special measures, like Singapore. They said that it is stipulated that milk fat should not be less than 26%, say, for example, or the moisture content. Now, baby formula is supposed to be dry, but then if it is not totally dried, the nutrient or the composition may not be the same. Then the moisture level should not be more than 5%. And then there is also a stringent requirement that there should not be any additives apart from vitamins. for our regulation, are we not heading towards that direction? So can the government explain how come that we are not adopting such an approach? Undersecretary, Dr. Wong, you talk about tolerance limit. We are following international standards in drawing up the flexibility level. But if you require further information, we can certainly give that to you later. As for the additives, CFS, any supplement from you? Dr. Chan, under the regulations, we cover composition enabling of nutrients. We haven't included any requirements on the usage of additives. Composition, what about composition? Is that required? Now, for composition, as what the member said, we have requirements on total fat and so on. But for moisture, because for according to Kodak standards, there is no such requirement, hence no such requirement in our regulation too. Now, but for the other 33 nutrients that are required under the regulation. So in your supplementary information, apart from the tolerance limit and why you set a certain level, can you also spell out the standards in other jurisdictions for us as a reference, so we can compare Hong Kong with other jurisdictions? Does it mean that Hong Kong is exceptionally tolerant or not? Or are we more stringent than others? So can you give us practices in other countries so that we can make a comparison? Dr. Helena Wong. Thank you, Madam Chair. I haven't heard very clearly about milk fat that is already covered in the proposed regulations, right? Sorry? Is total fat composition that is required to be included in the label, right? What about moisture? And no additive. Would the administration consider including that in the regulations too? Well, nutrient composition, of course, is very important, but consumers are concerned first whether the claimed nutrients are sufficient. But then you said that 80% is already acceptable. I don't think that's acceptable. Second, we are also concerned about safety, and I'm sure that is a concern shared by the CFS. So consumers should have the right to know, apart from vitamins, other healthy nutrients, and also we would not like to see any other additives being included in the formula products. So can the regulations also tackle that issue as well? We don't want to come back, say, in 8 to 10 years' time to ask for the requirement of no additives. PAS? Apart from this labeling regulation, in the Public Health and Municipal Services Ordinance, there are a number of bylaws or subsidiary legislation setting out requirements on harmful substances in food, like additives, heavy metals, and also pesticide residues and so on. So these are governed by various regulations. The largest gap now is in the composition labeling of baby formula. So that's why we are trying to tackle this issue by our proposed regulations. Perhaps we can present the relevant information for Dr. Wong's reference after the meeting. Dr. Wong referred to the moisture level. Well, what she was asking is that there should not be too much moisture, rather than more moisture. So can you give us information on that point, whether you would consider adding in that point or not in your supplementary paper? I would like to clarify, no additives, heavy metal, and so on. These are governed by other regulations. Does it mean that apart from whether the product is complying with 1+33, you would also be inspecting the products based on other regulations, i.e. whether there is heavy metal, whether there is pesticide residue, and so on? Perhaps I would defer to the CFS to give you a detailed answer, but every year CFS does a large number of food product testing, and whether we have this regulation or not, the baby formula is being checked every year. Now, as for what kind of things we're looking for in inspecting the food, we would have to consider the market intelligence, the kind of products involved, and whether the product is subject to any contamination or what. So to put simply, to give a simple answer to Dr. Wong's question, yes, is a yes. Yes, we are looking at other regulations when we inspect food products. So I strongly urge that the administration seriously consider that a requirement of no additive should be added in the regulations. There is another question for CFS. You said that you would check 55,000 products every year. Now, in the past couple of years, how many products out of these 55,000 are formula, infant formula and follow-up formula products? And what are the results of your tests or checks? Do you have such information? Dr. Law. Is it the mic is not switched on or what? Yes, okay. We checked the labels of 55,000 products. Now, as for the composition, the number is 65,000 products. We can give you detailed information later on. What are the test results? Then we can give you the information. Now, the regulations have not yet come into force, so we will not be checking the labels now at this present stage. So, Madam Chair, such information is so very important. Please give us a paper on the items that you have checked in the past 2 years, infant formula, follow-up formula, the nutritional composition, and whether there is any heavy metal, pesticide residue, and any additives. Well, please give us all the data so that we can have a grasp of the situation in the market. Say, if the products deviate largely from the standards, then we must try to speed up our scrutiny of the regulation. Now, please wait for the third round. I have a question myself. My question is for the CFS. Now, if the regulations come into force, you said many times that you would check 55,000 products every year. Now, would you be checking more infant formula and follow-up formula afterwards, after this regulation comes into force? Do you have sufficient manpower? And also a question on the labeling. Advertisements is an important issue. And when consumers buy the products, especially those who buy the baby products through online channels, perhaps you can talk more about the online sales channels later on. Now, they have the labels, so the consumers have the labels, and they don't know whether after consuming the infant formula, the baby can really get so much smarter and have a better memory and grow healthy and good. So this is altogether a different issue from what we are saying here, 1+33, 1+29. Even with all these nutrition, composition and labeling requirements, that won't help the consumers to check whether the baby can really get healthy after consuming a certain baby product. So I think regulation of advertisement is important. I think the regulation should be implemented at the same time. Now, after the labeling requirement comes into effect, what kind of public education will you undertake? Now, I think online sale is a very sensitive issue, and I think you need to look at how the regulations should cover and regulate online sales. Now, even if there is not yet regulation, at least you must do public education so that consumers can get to understand the requirements. So I think that's very important. Fourthly, the regulation is similar to the nutrition labeling scheme. We talk about the size of the label and so on and so forth. We refer to the fact that labeling of a certain size would be exempted. Now, after the regulation on that other scheme came into effect, did you identify any cases where the size of the label suddenly got smaller so that the manufacturers could evade the regulations? I'm worried that that might happen because manufacturers would change the size of the label to evade the regulations. Thank you, Ms. Mack. Your first question. After the regulations come into force, would the CFS step up its inspection work? I think they do have a plan to do so because for any in the initial stage of any regulations, they would pay particular attention to irregularities. Perhaps the CFS can supplement later on. The second question about claims, health claims and advertisements. Ms. Mack, you were so right. We are all very concerned about the advertisements and health claims on infant formula. Apart from composition enabling, claims is something that we should look at. Initially, the CFS has started working on that front, and we found that there are different practices in different jurisdictions. Claims, there are always many claims, and there are also new claims every now and then. So the issue is quite complicated. Different jurisdictions have different arrangements and involves a lot of manpower to check on claims. So what the CFS is doing now is to take a look at what is being done in other countries and what Hong Kong can do. Now, our initial plan is that by the end of this year, we can have a public consultation on that subject. Also for the Hong Kong Code. So although this is a voluntary code, it sets out certain requirements on advertisements. Now, as for public education, definitely, yes, the CFS will escalate its efforts on public education and on online sales activities. We will give you further information later on. For the last question, perhaps the PAS can tell us whether we have information on hand, i.e., whether in the previous set of regulation, whether companies have reduced the size of the label as a result of the regulations taking effect. We didn't notice any such situation mentioned by the Madam Chair, but please allow me to ascertain from the CFS the situation, and then I can give you the information next time. Third round, Helena Wong, 3 minutes. Madam Chair, I suggest that we should postpone the public hearing to a later date because we are still waiting for a lot of information from the administration CFS report, tolerance limit. You asked a number of questions and they have to give an answer. So I think once the information is with us, we have to study it first and we get everything clear before we meet the deputations, because a lot of information is lacking from the paper now. And I think we should deal with the information internally, clarify before we meet with the deputations. All right, let me suggest that after the meeting, I'll ask the clerk to liaise with the members, and perhaps you can arrange for another meeting before we meet the deputations, because I want to do it really before the summer recess. I don't want to wait for too long. I think we should have at least one more meeting to deal with the information to be supplied later. Yes, we can liaise with members later on and have an extra meeting before the public hearing. Yes, any members, any other questions or comments? If not, Dr. Lang Kalau? No? Now, if not, then I would like to thank the government officials and members attending, and I hope that the administration can provide you with the information to us ASAP. Thank you.